Hello, dear viewers. Thank you for joining us. You're watching our weekly program, Talk to OBN on OBN Horn of Africa. I am your host and producer, Adis Asafa. Today, we're going to talk about transitional justice in Ethiopia. And I joined by one of Transitional Justice Working Group member, Mr.Misganaw Mulugeta, for his expertise and full insight about the application and implementation of transitional justice in Ethiopia. Mr. Misganaw, thank you for your precious time.
Thank you, Adis. Thank you for having me.
All right. To begin with, can you tell us about this working group and about its establishment this time?
Thank you for raising the question. The Transitional Justice Working Group is an expert working group that's undertaking the task of developing what we now call the policy options for transitional justice in Ethiopia. The working group is composed of experts that have been working on the area of transitional justice, that have been lobbying for some sort of a transitional justice policy in our country, and experts who have worked in the justice sector for the past decade or so in Ethiopia. The working group started its work by compiling a huge research on the experience of other countries on transitional justice, why it is relevant to our country, and some of the attempts that Ethiopia has made previously in terms of implementing a transitional justice process. We are now at a very early stage. We have followed a very consultative approach to developing a transitional justice policy. So we are now in a stage that we call pre-policy consultations, where I'm sure you also have a chance to look at it. A transitional justice policy options was announced to the public. So the working group is now operating under full independence. It's a technical working group. It's established within the Ministry of Justice, but it has it's operating very independently from the political wing. It's a technical working group. It's designing the consultations. It's soliciting inputs from different sectors of the society, including elite consultations, but also community consultations in a wide range of areas in Ethiopia. So very briefly, that is the working group, and the working group basically, like I said, is tasked with developing some sort of draft policy for consultation. But I really wanted to be clear that the Ethiopian Transitional Justice Policy discussion is at a pre-policy consultation stage.
Okay.
This is not a policy, it's not implementation. So we're just envisioning, if we are about to implement transitional justice, what would it look like, what are our options, and how we should go about it.
What does it mean by transitional justice, and what is its essence, technically speaking? Because you are experts in the area of justice, legal studies, humanities, science. You see, can you tell me about the science of this transitional justice?
Transitional justice is conceptually an evolving concept. It has been very prominent, especially following the 1980s, where a lot of countries that were coming out of authoritarian regimes, or countries that were coming out of a very repressive past with grave human rights violation, were faced with basically two questions. One is, how can you ensure accountability to past grievances? How can you serve justice? And then the second is, how can you achieve peace through the process, reconciliation, redress, and compensation for victims? So transitional justice is a concept that has been developing in many different countries. The experience has been evolving. So the question was, in contexts like this, prosecutorial justice might not serve you all the purposes that a transitional justice would, because in a context like this, there are too many perpetrators, there are too many victims. So even if your justice system is very strong, it's impossible to prosecute everyone. So that's one aspect of it. The second aspect of it is the sense of this idea of sense of justice. What type of sense of justice is satisfied by prosecution? So prosecution will serve some sense of justice, but victim sense of justice is not only limited to seeing a perpetrator prosecuted. It's also about their truth being known, what happened to them, when, who did what to them. It's about reparation. They need to be, their harm need to be redressed. It's also about reconciliation, because in a lot of contexts like this, the violation has reached a point by which communities broadly are affected. And a lot of countries, a lot of contexts also require guarantee of what we call
okay, let me pause you here. You've mentioned this peace and reconciliation, right?
Yes.
It inculcates and it contains in it this a trend of having reconciliation and holding national consensus and national dialogue. But we have this National Dialogue Commission on board. Which should come first? Is that executing transitional justice, or undertaking national dialogue, then proceeding to the transitional justice?
Yeah, that's a question that I think many ask, but I have to say I have to finish the conceptual framing of transitional justice. So what transitional justice says is there is a need of justice, prosecutorial justice, but there is also a need for transforming societies. So the idea of transitional justice is about comprehensively implementing various modalities, not excluding justice, not excluding persecution, but also in addition to persecution, pursuing what we call other components of transitional justice. Now, let me come back to your question. There are different experiences in the world about the relationship between national dialogue processes and transitional justice processes. What must be very clear is they are not one and the same. They are related concepts, and in some areas there might be some convergence, but transitional justice and national dialogue are different processes. In some countries, what they have done is they sequence them, but some other countries have implemented transitional justice and national dialogue processes together. In some of these instances, usually the process would include some national dialogue aspects, but also transitional justice aspects. Some other countries have also tried it separately. So I think in our country, yet we are in a pre-policy consultation process. So one of the questions that document asks is whether or not we establish very strong complementarity between these two processes. So transitional justice, the state of the art now, has around 6 components. So one of the components is clearly prosecution. The other is truth finding or truth seeking. The other is amnesty. The other is reparation. And the other is institutional reform. So even in the policy options paper, we have indicated that at least 3 or 4 of these components could be implemented by the existing National Dialogue Commission. Of course, you need to amend the establishment law and maybe expand the commission itself. But we have also presented the risks with that. One of the risks with that will be both processes are rigorous. They are going to take a lot of time. They are very delicate and sensitive processes. So the downside of that would be adding more burden to the national dialogue process. We have also recommended establishment of maybe a new commission to look after the transitional justice process, but also work in complementarity with the national dialogue processes. So I think conceptually what must be clear is these two processes are not mutually exclusive. They are complementary. And as long as we ensure their complementarity, we think it's important to implement both in an effective manner to solve the very complicated political problems that we have in this country.
Okay. What are the criteria to undertake this transitional justice?
Well, to be honest, other countries' experience also indicates that there is no really set formula for undertaking transitional justice, but there are some known evidences. One of the things is transitional justice is more effective in places where there are widespread human rights violations. Number of perpetrators is really beyond the comprehension of the normal justice process. Number of victims is too many. In a lot of places, the institutions that render justice are deemed ineffective to undertake this task. Rule of law is weak. And then the need to realize peace and, globally now, it's, I think, the most accepted principle that peace and justice are not necessarily mutually exclusive. If you want to have a sustainable peace, you have to serve both justice and peace equally. So transitional justice have been tried in these places where victims are many, there are traditional issues, there are a lot of grievances that a comprehensive policy, a comprehensive process such as transitional justice will serve the purpose. So it's really a developing concept. If you look at countries that have tried it in the 90s, there are a lot of lessons drawn out of that. From the 2000s, there are a lot of lessons drawn out of that. So now, at least the advantage of Ethiopia trying to embark on a process like this is we can learn from the experiences of this country and then adopt it to our context. But I think the most common feature is, like I said, grave human rights violation, too many perpetrators, too many victims, and then the need to not only serve prosecutorial justice, but also to comprehensively serve components like truth-finding, reconciliation, reparation, and institutional reform.
Let's talk about the stakeholders in ushering this transitional justice. Who are the stakeholders mainly?
Well, a national transitional justice process really is meant to serve victims, perpetrators, elites of a country. So one of the principles in, for example, the African Union has a policy on transitional justice. And one of the principles it says is the best practice in terms of transitional justice indicates that it must be nationally owned. So I think everybody, every Ethiopian is a stakeholder in this process. Especially in our context, I think we need to ensure participation of state actors, non-state actors, civil society organizations, the media, but even individual citizens. That's why in this process, like I indicated earlier, in the pre-policy consultation process, we thought it's important not only to talk to the elites representing different sections of the society, but also the community itself, the victims themselves. So the approach we're following is we're now undertaking community consultations in many different places of the country, really hearing from communities what their sense of justice is. So what they feel about who should be prosecuted, what type of crime should be prosecuted, what type of reconciliation processes we must undertake, what institutions should do it. So really, nobody should have a monopoly over an agenda like transitional justice. We will be more successful if we make it a public agenda, if every Ethiopian feels they have a stake in it and take part in it, participate in it, and it will be able to. And transitional justice is not a silver bullet. It's not going to solve all our problems, but if we implement it effectively, I think it will satisfy at least the sense of justice that everybody is craving for. Because one of the things that, if you talk to a lot of people, one of the things that have been missing in Ethiopia is that element of justice. Where is my truth? This has happened to me. Where is my justice? Where is my perpetrator? So I think that, like I said, the natural stakeholders are, all national institutions. And of course, government has a huge stake, but the idea is processes like this, the more publicly owned they are, the more effective they'll become. So in a nutshell, I think everybody is a stakeholder. All organized groups such as civil society, media would need to play their role in terms of not only designing a policy, but also ensuring the effective implementation of a transitional justice process.
Are you fully independent from government or any other bodies?
Yes, I would. Again, what must be very clear is the policy-making process must be disentangled from the implementation process. The policy development process is really a technical process. So for us as a team of experts, we don't make decisions. We analyze other countries' experience, we take inputs, at the end of the process, the idea is we sort of submit a draft policy on how to take it forward. This is a policy-making process which is being led technically, and we are also operating independently. But the implementation of transitional justice, once the policies are adopted, institutions are established, one of the key principles is there must be independent, legitimate institutions leading the implementation of an effective transitional justice processes. So if you look at the policy options paper, so for example, one of the recommendations is to establish a new commission, right? And the key principles to that would be to make sure that that commission is established independently, so that perpetrators and victims consider it as impartial from whoever had a political interest. So that must be ensured. Court processes, prosecutors that will undertake the prosecution aspect of a transitional justice process must also be established independently. So what must be very clear is, one, the two processes, policy making, which the stage we are in, and implementation, which is going to be upcoming. So what I want to stress is, at that stage, we need to also make sure that these institutions are independent in their establishment and in their operation. So that will be something that will be coming in the future, but the principle is set. The principle is that, as you indicated, an effective transitional justice process requires independent, legitimate institutions. And I hope this process will midwife such institution, but safeguarding that is also the task of the media, the civil society, and the broader public to make sure that these institutions are really as independent as they are in paper.
All right. Before sitting for this interview, I tried to go through various literatures regarding this transitional justice, and as a showcase, Tunisia, Colombia, Rwanda, Yemen, and others have undergone a very successful national transitional justice, and they have solved their problem. I mean, have you gone through such showcases to use it and to adopt it? And I mean, a case of Ethiopia.
Yeah, I mean, a lot of transitional justice processes attempted in various different countries have some successes and some challenges. So for the countries you mentioned, for example, it's not only successes that all these countries have, it's also some failures, some challenges, and some shortcomings. So we realize that any transitional justice process must be adapted to the country context. So in our policy options, we have consulted, we've seen experiences of these countries. I think the most people relate to is, especially in African context, Rwanda, and maybe South Africa also is mentioned frequently in terms of countries having had successful transitional justice processes. But even those processes are criticized for some of the shortcomings. So for instance, the South Africa one is criticized for not having a broader prosecutorial mandate. It's criticized for focusing a bit more on reconciliation, on truth finding. And you can mention any of the attempts, and there could be some strong sides, but there are also some challenges. So our formula has been, we have to learn from this, but we cannot copy paste. It's not what worked in Yemen, if it has worked, and the Yemen one is really faced with a lot of challenges, as you can see. There are others who have also attempted. Even our neighbor Sudan had some process. Kenya had some process. So it's a lot of countries have done some processes with transitional justice, and the key lesson is what worked in one country cannot be said to work in another country. So the recommendation, therefore, is countries must adopt a transitional justice policy that's context-specific, which means it has to do with your cultural, political establishment, your history, the type of problem you have, the type of transition that you want to, that led to the undertaking of a TJ process and all the rest of it. And the second one, it must also be nationally owned. So yes, the working group has consulted the experiences of others. We have looked at what worked well, what hasn't worked well, but we still said, oh, we need a pre-policy consultation instead of giving a policy draft, because we also need to understand the national context better. So one of the purposes of this pre-policy consultation is also to understand our setting, our problems. What do people feel about justice? What do people feel about reconciliation? What do people feel about institutions? So it will enable us to sort of come up with a policy draft that learned from other countries' experience, but is also sufficiently country-specific.
Mr. Misganaw Mulugeta, thank you for your expertise and valuable insights. I really appreciate on behalf of OBN Horn of Africa.
Thank you for the opportunity.
Okay. Dear viewers, this brings you the end of our edition for today. See you next time with another edition. Bye-bye.